Ladies and gentlemen, I welcome all to my channel. Today we are going to discuss about the judgment passed by the Supreme Court with respect to the Madrasa Education Act. Previously, the Allahabad High Court held that the Madrasa Education Act passed by the UP government is unconstitutional, ultra virus, and so they have struck down the law. In addition to that, they have also given direction to the government to form a scheme so that all the students studying under the madrasas, the schools, to be taken care of, and they have to be shifted to the regular schools, like what the Allahabad High Court has given a suggestion to the state government. In pursuance of the High Court judgment, the UP government, the present UP government, accepted the verdict of the Allahabad High Court and issued a notification in which they have directed all the institutions who do not have proper recognition to be closed, and they also took steps to shift all the students studying in the madrasas to the regular school. As against the same, an appeal, SLP was preferred in the Supreme Court. The Supreme Court initially stayed the Allahabad High Court judgment as well as the notifications, and consequently the notification issued by the government was also withdrawn forever. And the arguments were produced in support of the Allahabad High Court judgment and as against its verdict. The main contentions of the contentions are they claimed that the Act violates Article 14 of the Constitution and Article 21 of the Constitution, and also the Right to Education Act and the Article 28 of the Constitution. Like what the persons challenging the Act raise the points. Article 14 describes about discrimination. So the Constitution prohibits discrimination. They said that since all the other students, since there are two types of education, one through secular way and the one through madrasa, it creates discrimination. So it violates Article 14, like what the argument was advanced. And again, Article 21A displays compulsory education to schools, to the children, and by way of studying in madrasas, the proper education is denied and deprived to the students, and so the Madrasa Act violates the Article 21A of the Constitution and this type of argument was also advanced. Again, and Article 28 Article 28 prohibits the religious instructions, and they say since this act regulates recognizes the education through madrasa system, they said that it also violates Article 28A, which prohibits religious instructions to any students. So, like what the arguments were advanced. So, after hearing the arguments of both sides, the Supreme Court has held that regarding the legislative competency, the state government has power to enact laws with respect to the education, which comes under a concurrent list. So, with respect to education, both state government and central government can pass laws. So, this act was passed in pursuance of this concurrent list 25, and so they said the legislative competence of the state government was upheld, and so they said that the state government has legislative competency to pass the order, to pass this act. Regarding the other aspect also, they said that the act cannot be held invalid just on the ground that it violates the secularism or the basic structure of the constitution. In order to hold the act invalid, then it must be pleaded that it violates any specific provisions of the constitution. Just because of raising a plea that the act violates the entire constitution or entire principles enriched in the constitution, or so it violates the secularism or it violates the basic structure of the constitution. Like what if any act was held invalid, then it will give a vague uncertainty over any acts. So, in order to declare a act invalid, it should be specifically pleaded that it violates the specific provisions of the constitution, unless and until any act violates any specific provisions of the constitution, it cannot be declared as unconstitutional, like what the Supreme Court observed in its judgment. In addition to that, the Supreme Court has held that with reference to the education, undergraduate education and postgraduate education, it will come exclusive control of the central government, union list. So this act, which recognizes the education for COFIL and FOSIL degrees, which is equal to undergraduate and postgraduate degree, are concerned, that subject comes under the state exclusive control of the union government. So that the act with respect to the education, with respect to the undergraduate and postgraduate, are held invalid. So ultimately, the Supreme Court has partly declared the Supreme Court upheld the act. However, some of the provision which relates to education, postgraduate education and undergraduate education alone were declared as invalid. So the consequence is that if the Allahabad High Court judgment is upheld and it is implemented, then the fate of the 12 the peoples who are studying in madrasas would have been in trouble, because the Allahabad High Court judgment not only declared the act invalid but also give a suggestion to the state government to frame a scheme to accommodate all the students studying in the madrasas and to shift them to the regular school. So if the Supreme Court has not passed this order, the fate would have been all the madrasas which has been functioning in Uttar Pradesh would have to be closed, and all the students studying in the fate of all the students studying in the madrasa will be in trouble, and they will have to be accommodated in regular school, like what the situation was there before passing of the judgment. Now, after the passing of the judgment, the students studying in the madrasas and the institutions run by the madrasas under the UP Madrasa Education Act would have been happy, because the act was held valid and they are entitled to run the madrasas and education, conduct education to the school students as per the act. However, the education with respect to the postgraduate degree and undergraduate degree are declared to be invalid, and it was held that the state government cannot pass laws with respect to postgraduate or undergraduate degree. So the provisions of the Madrasas Education Act with respect to those provisions are declared invalid, and so the act will not apply to the PG and UG degree certificate. This is the law. This is the judgment, and this is the contents of the important aspects of the judgment. I hope this video will be useful to those persons who wanted to know the real contents of the video. I will come again with another topic. We have two channels, Razziak Law Tube and Razziak Satnam Variyom. One is in English, one is Tamil. You may watch my channels and you may also watch my videos in my website, which is Ali Associate Chennai in Google sites. So I will come again with another topic. Until then, goodbye. Razziak Ali.